Welcome, fellow business brokers. Thank you for joining us today. Today, we're going to talk about legal issues when you're buying a business. And I'm really excited because we got with us today attorneys Ken Gluckman. How you doing, Ken?
I'm good, Jim. Good to see you.
Good to see you, buddy. And we got Stephen Kuttner. How you doing today, Stephen?
Just fine.
All right, excellent. And we've got Deborah Carmen. Thank you for joining us, Deborah.
Good to be here. Thank you.
All right, excellent, everybody. Let's just jump right in because we've got a lot of questions that I want to go over. So we've got a lot to cover. So I just want to jump right in. Stephen, when do you suggest somebody should use a asset purchase agreement, and when do you think somebody should use a letter of intent? You know, when do you think somebody should use each one of those?
Letters of intent, if it seems like they're necessary to determine if there's an agreement between the parties, then I would suggest doing it, maybe in larger transactions. Typically, it's a lot of time spent on the letters of intent that's wasted time, especially if there's attorneys involved, because they're worried about the language in the letter of intent, and the letter of intent's generally non-binding. So just a lot of time goes into that that's unnecessary. So I would suggest using them sparingly, maybe when there are a lot of terms in the transaction that you just want to make sure that the parties have a meeting of the minds, do it. But they can have issues if certain portions of them are binding, which means that, again, it's just, I think, unnecessary time. In most cases, I prefer to go to contract right from the beginning if the parties are serious.
As a business broker, I do too. Go ahead, Deborah. I'm sorry.
Well, I was agreeing with Stephen. I much prefer to have an agreement than have an LOI. The only times I really see LOIs now are these large companies looking to acquire different businesses, and I see those LOIs, and they are usually 15, 20 pages long, and might as well have had a contract.
Great. You know, this is my thing about, I feel the same way. As far as the APA, like the Business Brokers of Florida has a standard asset purchase agreement. I know a lot of other state and regional organizations have standard asset purchase agreements, and sometimes they're great to use, and other times it's better to have a contract drawn up from scratch, or use a different model. When do you guys suggest that with your buyers?
I think it's
a transaction. I don't know who you want to answer that first, but
yeah, sorry, I should have. I'm doing a lousy job today. Ken, go ahead. I'm just throwing questions out. You guys are like, who are you asking? Ken,
I'll just chime in.
Go ahead.
I really, to me, a lot of it depends on the size of the deal and whether the sophistication of the buyer, and a lot of that the size of the deal is going to actually be a part of that determination. So if you've got a more complex deal, you really need to have more detail, more information, and other items of a contract. So the standard contract is not going to be as effective. I think if it's a smaller deal, you can come in with a standard contract that the broker can put together, then that makes sense.
Great.
And then we can always add an addendum to the standard contract as well.
All right, excellent.
One thing I'd bring up on that, Jim, and I don't know if you're going to get to this later on, but and it kind of goes to what Deborah said as far as adding an addendum. Oftentimes, the parties execute the contract, then take it to their attorney when it's a BBF contract, or their standard industry contracts. And I know the BBF contract has their clause, it's 46, paragraph 46.
Contract review.
Yeah, which I think's fairly meaningless, never should be relied upon, is oftentimes probably used by brokers to say, well, don't worry about the contracts, you've got 5 days to have it reviewed. But representing a buyer, if they contact me and they say, well, the broker told me to go ahead and sign it, and you've got 5 days to review it and make changes to it, I'll generally caution them to not do that.
No, that's good advice. And what we look at, if they have done that, is certain changes no one wants to make. For instance, escrow holdbacks. Nobody wants to put in an escrow holdback after there's nothing in the contract, but many times it's necessary to do that. So we have to change the terms. And many times too, the buyer doesn't even realize what a non-compete is and what the geographic limitations should be.
Right. I think it's important for us business brokers that, if a buyer or seller want to have an attorney to review it, they need to have it reviewed prior to signing it. I think that goes with every contract out there. And, I know as a business broker, I always encourage people to talk to an attorney. No matter what the size deal is. Some of them say, yeah, I want to talk to an attorney, and some don't. But you can't sign a contract and then go to an attorney. It makes it a lot more difficult, doesn't it?
But it's implied in the BBF contract that you can do that, which is, I don't know why that's in there.
Yeah, and I think it's like that in a lot of the state and regional contracts and, out there, unfortunately. So about stock and asset sales. If you guys just give, maybe Deborah, you can give a 60-second rundown of when you think it should be a stock sale and when it should be an asset sale.
Most of the time, I would say it should be an asset sale. Sometimes we do stock sales for a couple different reasons. Sometimes we do them for licensing and permitting to make it easier. Sometimes we do it for a landlord situation. So it really depends upon what they want to do and what they want to accomplish. Most of the time, though, I'd say probably a good 99% of the time, we're going to do an asset sale. And the asset sale is better in the sense that there's no liabilities unless you've gone ahead and assumed them. When you have a stock sale, you're assuming all liabilities.
Okay. All right, great.
Jim, I think it's important, it's helpful for people to understand that a company is really like a bucket. And in that bucket, you've got assets and liabilities. So if you're going to the best thing to do is to just scoop out those assets that you want, leave the liabilities in the bucket. Because if you buy the company, you're buying the whole bucket. It comes with the good and the bad, and that's what you're stuck with. So I think that's important to understand.
And, I was thinking too, Jim, a lot of times it's used for immigration purposes. They'll want them to have the stock and not an asset sale.
Okay. All right, great. And let's talk a little bit about if a seller has a piece of property and the business and they're selling both of them to somebody, obviously they need a separate contract for each one. A contract for the business, a contract for the real estate. I don't think we need to talk about that, but I did want to mention that real quick, unless one of you guys want to chime in on something with that.
I only want to talk about that because most of the time I just see the asset sale and I do not see anything regarding the real estate, and some of the terms are going to be up for negotiation way after due diligence has been done, because that's sometimes when we get the contracts and then we have to sit there and say, well, what's happening over here? Who's paying for what?
Right.
And that can become an issue. If it's a large piece of property, nobody wants to pay for the title insurance.
Right. And Jim, I get BBF contracts. I'd say a few a year that in these special clauses, it says real estate is included.
Yes, that's what I get. Mm-hmm.
Yeah, it's important, Jim, for people to realize that you want those contracts to depend on each other. One doesn't close without the other closing. And there are some very specific terms about the real estate that we need to know to make sure the parties have laid out what's going to happen.
Well, I'm glad you guys brought that up because I didn't realize that was an issue. So I'm glad you guys brought that up. Yeah. So anybody that's listening right now, if you're not aware, you should have a purchase contract for the business, and you should have a separate contract for the real estate, because like the BBF contract is designed for a business. It's not designed for real estate. Most of the time, a business owner, has two different corporations. They have a corporation for their real estate, their building, and a different corporation for their business. So you need those two different contracts, but those contracts should talk about each other in their contract. You don't close one without the other. I mean, that's to sum it up, right?
What you're saying, because also the environmental issues come up, and if they're not addressed in a contract, you're going to be addressing them later.
Yeah, because there's not all the issues that are in a standard purchase contract for a business. That doesn't address the issues that you need to buy real estate, and vice versa. Like I've seen real estate agents give me a contract from their buyer on one of my listings, and it's a commercial real estate contract. And obviously that doesn't cover the business. So, we got to have one for each one of those.
I had an unusual closing just last week where we closed the business for SBA, and the other attorney closed the real estate because that's how it was set up. Very strange.
So, Stephen, you wanted to talk today about, how you try to encourage buyers to put contingent or deferred payments when they're buying a business. You want to touch on that a little bit? Earn-outs, et cetera?
Well, especially in a climate that we're in now, where you can't rely upon the past successes and the past financials of a business. You're going to see this in any economy like this, but I think it's good, really, no matter what the circumstances are, that the best way that a buyer can buy a business is to keep the seller honest, to make sure they're getting what they think they're getting. And mostly what buyers are buying is a stream of income. They're typically not buying a bucket of assets. They want the income from those assets. And if they're going to pay a certain amount for the income, they want to know, more than we as attorneys know, they want to know the stability of that income. How reliable is it? Can they depend upon it in the future? And having these deferred payments that are tied to either client retention, tied to future revenues of the business, tied to the fact that there are no liabilities that will arise in the business, tied to training and familiarization by the seller. all those, because we're talking today about buyer aspects of transactions, all of those are in the buyer's interest. All of those a buyer should try to include in most sales if they can do it. Sellers will resist it, but if sellers certainly understand the climate we're in now, if I was buying a business, or when I do advise buyers to buy a business, it would never be based upon prior income in the climate that we're in without something that ties it into future income, ties the price into future income.
Right.
And it doesn't have to be a promissory note, Jim. It can be also an escrow holdback. We've done that as well.
All right, great. Great. I think this is a good time to remind everybody, today we're talking about, from a buyer's perspective, the three attorneys that we have on today, Steve, Ken, and Deborah, we're talking from the buyer's perspective when they're buying a business, how they should be protected. All three of these attorneys do work with buyers, but they also work with sellers. And, a couple weeks ago, 2 weeks ago, we did a similar webinar and we talked about, what a seller should be looking for. So you got the buyer's hat and the seller's hat that you have to wear as an attorney. And, I really want to say that as business brokers, we should be encouraging our buyers and sellers to be talking to attorneys that deal with this stuff all the time, because you guys know what's normal and what's not normal, and when you guys are negotiating with another attorney, it makes it easier on knowing what's normal. When you start involving attorneys that have never been in the process of selling a business, and they're digging their heels in on issues that are not normal, it just makes it a lot harder. I mean, is there anything I missed in that conversation there, guys?
No, I think you summed it up very well.
You got to have an attorney that does business transactions representing you as a buyer or seller. That basically is the bottom line. So what kind of things do you guys talk about, Ken, when it comes to licensing issues? What kind of conversations do you have with a buyer?
Well, we want to look at, what intellectual property the business has, and we want to understand, first, is there a franchise company involved? I think that's important. That has a lot of specific details that are different in different deals. We need to understand who the franchise company is, how they structure their franchisees, if there's a transfer cost, things like that. But then some entities do it in the way of licensure. And oftentimes it's not actually proper to just license intellectual property if they have additional controls. That's the difference between a franchise and a license deal. So it's important to understand what is being licensed, what the terms of that license are, and whether it's transferable, how it's going to be transferred, and how that impacts the buyer as far as what they want to do with the business post-closing.
All right, great. And Deborah, what do you talk to them in terms of governmental licensing?
Well,
buyer.
That's a great question, because you need to have an understanding of the business, and you need to see if the buyer actually has qualified, is a qualifier of that particular business, or whether or not you need to sell or to stay on. And that's a very important situation. Also, there's other types of businesses involving healthcare where you have to, or under ACA. There's a lot of different types of governmental rules and regulations out there, and you want to be very careful then what they are, because if the buyer comes in that business and doesn't know what he's doing, he's very dependent upon a seller.
Right. You can't get the license, and it takes a while. And I know if you're doing an SBA loan, typically the banks or the SBA does not like somebody having a license for, the seller carrying the license for the company for more than a year. They want to keep it under a year. So that causes that issue as well.
Exactly. And it could be 2 or 3 years before that person will be qualified then to run that business.
Right. Okay, great. Hey, Stephen, maybe you could talk a little bit about reps and warranties from a buyer's perspective.
Get as many as you can.
Maybe start off explaining real quick what reps and warranties are, and then, give us some examples that you encourage buyers to look at.
All right. Even the BBF contract has some representations and warranties. And what representations and warranties are, it's the seller, and oftentimes the principals of the seller, if you're representing a buyer, you want to make sure they're there. They're representing certain aspects of the business in writing. And generally, what they represent in writing in the contract is all they represent. So they're representing maybe no litigation, that certain contracts that are attached are the only contracts, that they have certain licenses in place, they have certain assets, the assets are in a certain type of condition. Anything that's material to the sale of the business that a buyer would want to know is true and accurate, the buyer would want to have a representation and warranty in the contract, because the seller's then saying, you can rely upon this. I'm representing it to you to be true. I'm warranting it to you to be true. And then along with that, there'll be another paragraph in the contract that where the seller indemnifies if they're not true, and gives the buyer the right to walk away if before closing it's determined that they're not true. So from a buyer's perspective, there's probably nothing more important in the contract than representations and warranties.
Okay, great. Deborah, Ken, do you have anything to add on that?
Well, yeah, go ahead, Deborah, sorry.
Go ahead, I'll go next. Go ahead.
Go ahead, Ken.
I was just going to add over there duration. You want to make sure that the duration of the reps and warranties is there as well. And I try to get them personal identification then by the principals of the seller, so it has a little more weight to it, because of course the company is going to get dissolved or it's going to go away and there's no assets. You really have to have some personal liability there on the part of the principals of seller to give it some meat.
Okay, great.
So that's another aspect of reps and warranties. And in COVID, I just wanted to say too, it's become a really, really interesting situation because there's so many factors out there we don't know about. For instance, there could be really good lease terms and there could be all kinds of things given by a landlord that we don't know ahead of time that they've done for the seller. So you always have to get, the seller's estoppel information for that as well. There could be a PPP loan out there that they want the buyer to assume. Some of these lenders now are making the buyers assume the PPP loan liability. So there's a lot of different issues that COVID has brought forth.
All right, great. Thank you, Deborah. Ken, did you want to add anything, or did Deborah cover it?
I think that's fine.
Okay, great.
Let me add one more thing to it. One thing that I do, and I don't know if Ken and Deborah do, but I found it to be a good thing to do from representing a buyer's perspective, is I know there are certain relevant financial documents that you'll gather for a buyer, such as profit and loss statements, tax returns, and balance sheets for maybe the last 2 years would be particularly relevant. I know those documents exist in most transactions. I know that you've got those in most transactions. In every transaction I represent a buyer, and I have a rep and warranty in there that says that the attached financial documents are accurate.
Yes.
Or materially accurate. And I have those as an exhibit to the purchase agreement, because if you want to keep a seller honest, you'll do that. And a seller is less likely to provide financials that aren't accurate when they have to specifically say in the contract that these are attached to the contract and the buyer can rely upon them as accurate. It also helps if you have to sue for fraud down the road.
Right.
Right. No, we do that. And we also have for SBA, that's requirement usually as well.
Yeah, I think sometimes, people take for face value that they look at a tax return and it says 1120S in the left-hand corner, and, they think it's the tax return. There's a reason why banks, when they're lending, require a tax return transcript sent to them directly from the IRS, is they want to make sure that that's the tax return that was actually filed with the IRS. I have seen personally in my 20 years 2 instances where a seller tried to pass off a 1120S form of a tax return that wasn't really the tax return that they filed with the IRS. So, I just kind of want to put that on record too.
No, that's interesting. And what sales tax reports as well, when they don't jive with the IRS, it's amazing over here. People will have 2 different sets. One for the tax return and one for the sales tax.
Okay. Yeah.
The numbers don't match.
I think we lost Ken. I think he got bored of us and he left us. Hey, Stephen, what kind of conversations do you have with a buyer about liabilities?
I generally tell that in an asset sale, most liabilities don't transfer unless they show up as liens, unless there's a UCC filing, which I generally check, because you can do that online. I generally check even when I'm meeting in my first time with a buyer to see what the seller has out there, so that I'm aware of that in my initial conversations with the seller. But unless it's a sales tax lien, some other tax liens in certain instances, or a recorded lien against a business, generally the buyer's not going to have that liability. Mm-hmm. So that's why we do asset sales. But I try to at least again in the contract, have a very clear warranty from the seller that there are no liabilities other than A, B, C, and D, so that they don't carry over to the buyer. And if they do, the buyer has some recourse. And again, there's usually escrow set up for that purpose. I make sure that the buyer has the right of offset in any note to the seller, and I'll encourage a note to the seller in every transaction so that the buyer has some recourse in case that exists.
Right,
Or at
we do
least
the
some,
same thing, and we look for an escrow holdback there as well if there's no promissory note.
yeah, so I was about to mention was the holdback. If in case there is no note, there's a holdback at least. What about employees, Deborah? What kind of conversations do you have with a buyer about employees that work for the business?
I think it depends upon what type of business it is. Sometimes there's contracts that can be assigned from the employees, and that's always a good thing. Sometimes there's other issues where there's never going to be an assignment because there's not a contract that's going to be there. And what we tell sellers, we tell buyers actually, is that you need to find out exactly what the sick leave is. You need to find out vacation pay. Everything has to be taken care of at time of closing. Because while you're going to go ahead and end that employment with the seller, then you're also going to take them over as the buyer, and you don't want to have any issues with unhappy employees.
Yeah, you don't want to be in a situation where you close on a business in November and, they have Christmas vacation. Employees are due Christmas vacation. And yeah, it's an asset sale. Maybe technically you can say, yeah, no, I'm not responsible for that. But that's not going to go over very well with the employees, is it? So, those are conversations that you need to have is how are you going to take care of the vacation pay and the holiday pay. Stephen, do you have anything to...
My biggest concern, go ahead, Deborah.
No, I was just going to say one thing we look at too is to see how they're going to do a transition, because that's very important. If you just spring it upon someone at the end of closing, you're going to lose a lot of those employees. It's very important how buyer and seller work together. And we advise our buyers to do that and make sure it's a smooth transition.
I'm sorry, Deborah, you advise your buyers to do what? I'm sorry?
Make a smooth transition, to have a meeting with the seller and have everybody meet together and not just spring it upon employees. I've seen people do that on a regular basis. And I've seen buyers come in and they want to give employees less money. And that doesn't work for me.
Yeah, that goes up like a lead balloon, I'm sure. Stephen, you were going to say something?
What I was going to say, and I mentioned this in the last seminar that we had, if I'm representing a buyer and there are any key employees, including especially their top sales employees, if they don't have a signed contract that's assignable with a non-compete, or at least a non-solicitation, but preferably a non-compete, I don't generally have them buy the business. And I've got clients that they buy lots of insurance agencies, for instance, and they're really careful of making sure that that's in place. They look at their records, they know which employees bring in the most business, because it's a relationship-driven business, like many of them are. Like, in fact, most businesses are. And if you're not making sure that those employees can't compete against you when you buy the business, you can walk into a business, and I probably have at least one a year where someone comes in to see me where this occurred, where they walk into a business and within a week, nobody's working there anymore of any importance, and they're all setting up their own business and competing against them. And there's nothing left. They bought essentially nothing at that point. And that happens, it doesn't happen every day, but it happens enough, and it happens in different levels. Sometimes it's everybody leaves, sometimes it's one key employee leaves. But if you have a key employee and they can leave and take the customers with them, they're going to hold you hostage to get paid more than maybe they should be, or they'll leave and compete against you, and you bought nothing at that point. You bought a business that all the customers are now with an employee that works for somebody else or works for themselves.
No, good points. And I'll tell you, it's interesting, in COVID times, I had a sale that was postponed because the employees got COVID. And they're just very strange times. And we had to wait till they had, the 2 times it showed up negative before they could purchase the business.
And, with that being said, I, as a business broker out there dealing with buyers and sellers all the time, sometimes buyers, feel that, employees are key employees when they're really not key employees. I've had instances where buyers have met with the key employees prior to closing, but I'm not a big fan as a business broker them meeting with, general employees prior to closing. And, you really got to decide, is this really a key employee or not a key employee? And, what's the likelihood of them going out on their own? And I've done a couple transactions in the last couple of years where we've actually put in the contract that you know, if the business is selling for, let's say, $1 million, we put in the contract that $50,000 is going to be held back in escrow. And if that key employee stays with the business for 2 years, they get the 50 grand. And if they don't stay with the business, that 50 grand is then donated to a charity that's spelled out in the contract. That way the buyer and the seller have no interest in that money itself that's sitting there. And it's just, you know, the one person, and it's worked out really well. And that way, you know, it helps incentivize the employee to stay. So I don't know what you guys feel about that, but that's worked out with me.
No, that's
on
a
some
very
deals.
interesting concept. And what you can do too is you can actually give a bonus to an employee staying as well.
Great. Yeah, it's kind of the same concept, you know, but it's the bonus that they have to stay there for 2 years or whatever, 18 months or whatever it is.
Right.
In order to receive that. You know, another thing with employees too is you got to keep in mind is not just the holiday time, but the vacation time that they've accrued. You know, so
that's true.
you know, you don't want them to have 3 weeks of accrued vacation and you just buy the business, and you know, the moment you buy the business, 2 weeks later they're going on vacation. So, anyways, Stephen, what about the non-compete? What do you have? What kind of conversations do you have with the buyer about the non-compete?
It needs to be very specific, first of all. Maybe even more specific than you would typically see in the BBF contract. They need to know who needs to be a party to the non-compete, first of all. Is it the sellers? Is it the seller? Hey, welcome back.
Hey guys,
Hey,
I'm
Ken.
back.
Okay, we can't talk about Ken anymore. Is it
Yeah, I had a little technical difficulty there. I'm back.
is it the seller, the principal that's listed on Sunbiz? Is it their spouse? I'll generally want anyone that has any financial interest in the business, whether they be the principal spouse that comes in periodically, anyone that could potentially take the business away, anyone that has a strong client relationship, sign the non-compete. The non-compete should be as broad as where they draw their customers from. It should not have any outs that are not clearly written in the non-compete. So if the seller wants to stay in the industry, it needs to be very specific. What can they do? In other words, they can't do anything except this specific thing. They can work for this particular business. They can do this type of thing. No just general broad that the seller can do something unrelated to this business, some general language like that. It needs to say specifically, what can they do? Otherwise, they can't do anything that's related to that business whatsoever. So it just needs to be very, very specific. It needs to be long enough for the seller's relationships with their customers to be of no importance at that point. So it should at least be 3 to 5 years, although it can go up to 7, but it should be as many years as the seller's willing to do it.
But no more than 7 typically, right?
Well, no, we can do 10. If you have an
Can you
SBA
really?
loan,
Okay.
10, yes.
Yeah, I guess with an SBA, yeah. Okay. I'm sorry, Stephen, to cut you off.
Presumptively too long, but you could. I always like to make sure, why is the seller selling the business? Because I've had everything in the amount of years that I've done this, but I've had plenty of sellers that have remorse about selling their business. They go ahead and sell it because maybe their spouse wanted them to not work so hard. Then they get bored and they want to go back in the business, and they do. They just simply go back. They say, well, I heard Florida's the right to work state. I have the right to work, and they go work. And yes, the buyer can do something about it, but they have to do something about it, and it costs money and time, and their business could be destroyed in the interim. So I always want to make sure that the seller has good motivation for selling it, such as retirement, other businesses that are unrelated, because the non-compete is only as good as the amount of money you're going to put in to enforce it.
We talked about this on the last webinar that we did, where we talked about sellers and the legal issues that sellers need to be worried about. We also have a webinar that we did on, you know, what legal issues a business broker needs to worry about. So kind of doing all 3 of those parties. But I want to touch on this again. You know, a lot of business owners are under the assumption that non-competes do not work in the state of Florida, for instance. I don't know about other states, but a non-compete when you're selling a business does hold up, correct? Where it can hold up a lot stronger than a regular non-compete.
It's going to hold up because you're talking about a statute, you know, versus the right to work you have for an employee. So the employee is not getting the benefit of a business owner when he sells the business, but the business owner and the spouse are both getting that benefit.
Okay,
and I think
great.
one thing that Steve was talking about too is it's very important to have a non-solicitation clause in there as well. And not only just for customers and clients, but also for employees. Because you could have a separate location 10, 15 miles away, and all of a sudden all those employees are gone.
Yep. Okay. Hey, Ken, let's talk.
Jim, I'd like to chime in too that
Yeah, absolutely.
the Florida being a right to work state, I think it's important to understand that that just means that people don't have to join a union. It really has nothing to do with non-competes at all. And non-competes are absolutely enforceable. We see it every day. We see it with primarily physicians are the ones with the most money to enforce them. So there's a lot of cases out there about physicians, but also lots of other industries. And so they absolutely are enforceable.
Oh, they are?
Yes.
You know, they're very enforceable? Okay.
Yeah.
I didn't know that. See, that's why you guys are attorneys and I'm not. So, hey, so Ken, maybe you could talk to us a little bit about leases and, you know, what kind of conversations you have with the buyer about the lease.
Sure. It's really important for the buyer to get a copy of the lease, to understand what's in it, what's required. Is the seller personally guaranteeing the lease? Are they going to expect the buyer to personally guarantee the lease? What are the terms of the lease? How much time is left? Do they need to get a new lease, or can they get an assignment of the old lease? Is there going to be a fee for assigning the old lease, and how's that going to happen? What are the current interactions between the seller and the landlord? Is the seller current on their lease terms? Have they properly paid rent and taken care of the space and done all the things that they are supposed to do? And all of that's very important to understand as early as possible in the process.
And Ken, what do you feel about when you know, once in a blue moon we run across a landlord that we're trying to get the you know, lease assigned to a new person, and they're being very difficult in that situation?
Once in a blue moon, you said, Jim?
One where they're really trying to take advantage of the situation, I should say. You know,
it's not unusual, I should say, to see the landlord be difficult. We see it way too often. They seem to think that you know, they're the business owner or have some responsibility from everyone in the deal. I know Stephen has talked before when we've had these discussions about the idea that there's a tortious interference potentially by the landlord to not allow the deal to go through because they're being obstinate. But I think it's really important to understand, what are the landlord's issues? Are they worried about the, you know, credit worthiness of the buyer? Does the buyer have good credit? That's a good thing to talk about early on. That they can convince the landlord. If they're coming in from out of the country, they may not have any credit in the US, which is often a problem. We've seen some enormous security deposits required, and that can be a real pain, though we can try to negotiate that burning off over time if the buyer has the money to do it. So oftentimes it's worth it to them to come in, again, on maybe a visa situation, and they may be willing to put up money that you or I would think would be crazy to do, but they will do it. So it just depends. We need to find out what the landlord is looking for, why they're being obstinate, and how we can work around that.
And, you know, a good point to that. And we look for a story, because the landlords are always looking for a story for what the buyers have to offer. And they're looking for experienced buyers. They want to make sure they have experience in that industry.
Right. Stephen, anything you want to add?
The only thing I would add is I agree with Ken that if I'm representing a buyer, I want to get the lease right up front and read it very carefully, because what you're doing is you're relying upon how well the seller negotiated the lease maybe 5 years earlier. And I've had sellers that just simply sign whatever landlords put in front of them when they started their business. And now the business, where it's located, is very critical. The location is important to the business. And I go through the lease to see, is there any way that the landlord cannot continue that lease in place? I've seen plenty of leases where the landlords have the right to terminate leases under, if they remodel, if there's another tenant, one of the tenants in like a larger tenant, like Publix, wants to expand, if there's any minor damage to anywhere on the property from a casualty, various provisions where maybe the option periods, instead of having stated rent, say it's subject to negotiation, which again gives the landlord the right to terminate at will. So I'm always looking to see, is the buyer going to be able to stay at the location? That's a basic thing. You would think, yes, there's a lease, of course they can stay there. That's far from, of course they can stay there. The landlords, plenty of leases have provisions where the landlords can terminate the lease prior to the end of the term. So that's the main thing I'm looking for. can they stay there if they want to stay there during that term?
That's a major part of, you know, a buyer's due diligence is having an attorney review the lease if the business is dependent on that lease. Right.
And if you have an SBA deal, you want to make sure you have enough for up to 10 years for the terms.
Yeah, to cover the amount of time for the SBA loan. Yeah,
And
absolutely.
I've seen many deals fall apart because unfortunately the seller did not renew his option time.
You know, I think as business brokers, we get a little bit too shy of talking to a landlord about the sale of the business up front. And I don't know why, because a lot of landlords are large property management companies. They're out of state. So, you know, they're not going to tell anybody the business is for sale. And then also it all seems like there's a lot of local attorneys, at least in Central Florida, that tend to be landlords as well. And, you know, they're not apt to say anything, but, you know, having those conversations like, what are you looking for in a buyer? At least you get that criteria. And as business brokers, when we're, you know, talking to buyers, we can see if the buyers meet those qualifications or not. And I think we're a little too shy of not having those conversations with a landlord. So, Ken, what kind of conversations do you have with a buyer about the assets of the business that's being transferred?
Well, again, it's important, I think, for the buyer to, you know, understand the business and understand what kind of assets they need to operate the business fully and what condition are they going to get those assets in. They need them in working condition. When we're representing the buyer, we want to have them be in excellent working condition. We want to have the, you know, very strong language to what those assets are going to be like after the closing. They're going to be in, you know, excellent working condition, necessary for the business to operate fully in similar condition to what it's been operating in. So there's different language we can use, but it's important, I think, to get an asset list early on for the buyer to review the list, make sure it makes sense as far as what they intend to do with the business, and that those assets are again going to be in working condition and provided at the closing.
Great. Thank you, Ken.
So all
Stephen?
good points.
Oh, Deborah, go ahead.
No, I was just going to say, most of the time people do not attach asset lists to the contracts when we receive them. And sometimes it says that they'll be attached during due diligence. And I like to have them all attached at the time we have a contract.
Right, right. Stephen, anything you want to add?
I would say that I wouldn't just have on the asset list general and all intangibles and tangible assets of the business, and then just list the equipment on a separate list. I like to have an asset list that is more specific than that. If there's certain social media accounts that are important, certain email addresses, certain telephone numbers, all of those things, I want to have them listed on the asset list that's attached to the contract, because oftentimes they're not owned by the seller. And it needs to be very clear what assets the buyer intends to get. So if you've got a social media, especially in a smaller business, where the social media account may be under an employee's name, maybe an important email to the business goes also to an employee, or a phone number is an employee's cell phone number that the business uses for customers. I want to have that on the asset list. I want to know that that's what the seller is clear that they're going to have to own and transfer at the time of closing, not just some general whatever's owned by the business. Because then you get to closing, the buyer says, well, what about the website? You've got 3 websites and I want all the websites. And the seller says, well, we only have 1. The other 2 are run by employees for their own purposes and they do business on there too. Well, I want to know that everything that is relevant to that business is on the asset list. Whether the business owns it or not, I want them to represent and warrant that they do own it, and they're going to transfer it at closing. So at least if you don't get it, you've got some recourse.
And being very, go ahead, Ken.
Sorry, I was just going to throw in that another thing that I found very helpful is for the buyer to actually go in and take pictures of the assets if they can, as early on as they can. And if the seller doesn't want them on the premises initially, maybe it's just have the seller go through and take pictures. But having, you know, visual evidence of what is supposed to be there and the condition it's in could be very helpful for both sides.
Mm-hmm. And I think for, you know, from a business broker standpoint, knowing how small business owners, you know, operate on a daily basis, and I think Stephen touched on this, is that, you know, sometimes they have assets that they use for the business that the business technically doesn't own. And then there's things that the business owns but are not technically for the business. And then there's other assets in the business that, you know, might belong to the landlord. So it's almost like, I like to create sometimes up to 3 lists, a list of all the assets that are included in the sale of the business, all the assets that are not included in the sale of business that are owned by a third party that'll probably be transferred, things like, might be owned by a landlord or, even just a third party like Coca-Cola or whatever. And then a third asset, list of things like, that the company owns that are not being transferred, such as like a personal, the owner's Lexus car or whatever,
Right, exactly.
So,
Exactly.
and really spell it out, so that everybody's on the same page, because that's the biggest thing is with all this is just making sure everybody's on the same page. I mean, I know your guys' job is to protect your buyer or protect your seller. As a business broker, I kind of just want to put as much as I can on the table and just make sure everybody's aware of what they're getting and not what they're not getting. So
no, that's a good point, Jim. And what people don't realize many times, sellers don't realize what they own and don't own. Many times it's just
yes.
They don't. They have it on a list, and we're going through it. We're like, okay, where's this? Well, okay, that was actually leased. Yeah.
Yeah. So, what about inventory? What kind of conversations do you have about inventory, Ken?
Well, I think it's important to understand, is this a type of business with inventory? What is inventory from a legal standpoint? Sometimes we need to define it better. Sometimes the parties think it's things that it's not.
Right.
So I think it's helpful to say, because generally inventory are things that are sold by the business. And so
and they get it mixed up with furniture, fixtures, and equipment and stuff all the time. I see that.
Right.
Yeah.
Right. So they're not hard assets, though a lot of times they think of it that way. But because they're being sold for resale, there's a sales tax issue. There's other things that need to be considered. So I think it's very helpful to have an idea of what inventory should be on hand. If it's a restaurant, the amount of food on hand isn't technically inventory, but it basically is. And so how much food should be on hand on the day of the closing for the buyer to take over with? And is that factored into the price? That's something we look at in the contract of trying to have a minimum amount of inventory, but it definitely should be addressed and understood by the parties ahead of time before the closing.
And sometimes I agree 100%, Ken, and I think sometimes you need to cap the amount of inventory. I've seen it happen where all of a sudden the inventory is greater than the sales price, and all of a sudden you have to come out with cash.
Wow.
So you have to come out of pocket at a closing. It's not a good thing. Or if you're an SBA closing and you already know how much is allocated, and all of a sudden you start coming up with $200,000, $300,000 more of inventory.
Wow. I had a business a few years ago. It was a locksmith business that we sold. And I believe I did the transaction with you, Stephen, actually. And you may not be aware of this, but the seller had about $75,000 of inventory in the business that was not sellable inventory.
Yeah.
And so that was an issue that we had to work out. He had like $350,000 worth of inventory, but about 75 grand of that was not sellable. It was outdated for whatever reason of inventory. And it was a hard pill for the seller to swallow.
And that should be part of the buyer's due diligence. Checking.
I'm going to get in trouble too.
Yeah, we did that. And like, I don't think you even knew about it, Stephen. You were the attorney on that one. I don't know if you remember, but I don't even think you knew about that. That was something that was worked out during the due diligence process. The buyer and the seller are both good people, and they both did the right thing.
If you get a little nervous and you see convenience stores and you see everything is outdated by a couple of years.
Yeah. There's dust on everything. So anything else?
I'm sure, Jim, you probably had a transaction or two where I know I've had this, especially in convenience stores and clothing stores, where the seller will bring in inventory from that at cost. He's going to be recovering the cost from the buyer as part of the sales price because it's in addition to the sales price. And they'll bring in inventory. They'll buy it specifically because they can buy it lower than cost, show a profit in selling it to the buyer. I've had sellers do that.
Wow.
Bring inventory that wasn't even part of their business because they're going to be able to make money on selling that inventory to the buyer.
Thank goodness I haven't seen that.
I want to add too, Jim, that you might want to get a third party to do inventory, especially if it's a liquor store. You don't be sitting there counting every single bottle.
All right. So that locksmith business I was telling you guys about, this was like 7 years ago, maybe longer. It was probably 10 years ago now. We did hire a third-party inventory company. And the seller closed the business at 9 in the morning because he had tons and tons of inventory. And he closed the business at 9 o'clock in the morning. We did inventory all day. He brought in a third party inventory company. And about 11 o'clock at night, the inventory company told us that their guns they were using lost all the information.
Oh.
So it was not a good thing. So anyways, anything else? Do we cut? I know, Ken, you talked about intellectual property. Is there anything we want to add to the intellectual property? Because that's huge right now. You got people that own YouTube accounts and, Facebook, LinkedIn and all that. Is there anything that we need to add to that? I know we touched on it.
Yeah, it's been touched on in different ways. I think it's really important to first make sure they have a list. Make sure that buyer gets a list from seller of every trade name that's being used, every product name, if it's a product sold, created by the business that they sell, any licensed information, any social media accounts, if they use Twitter, if they have an Instagram account, if they have Facebook, and to make sure, and domain name, that all of that is listed out, and all of it is figured out. How do you switch that over? Because that's another problem we see a lot of post-closing. The seller has now gone on their vacation. They've decided to go as soon as it closes, and buyers looking to transfer over a Facebook account, and it is very difficult to do. Oftentimes they have to close one down and start up a new one, just because the seller didn't properly figure out how to transfer it and didn't provide, or it wasn't included. They didn't address it at all is often a problem. So looking at those things, trying to get a list of passwords prior to or at the closing. Really, seller should bring a list of every site, every password, every item, so that buyer can then smoothly transition into the business and take over that intellectual property. There's also a consideration of, do you need a separate assignment? If there's a registered trademark, you're going to need an assignment agreement to then submit to the the government trademark office to assign that trademark, transfer it over to the new owner. That's very important.
Okay.
And one thing I want to add too, Jim, is that people don't realize the seller has the same name many times as a fictitious name is going to be, and they don't have the seller changing his corporation. His corporate name remains the same. It's very confusing. It's very problematic. So we always make sure we give them, if they need 30, 60 days, whatever, or it's transferred many times right at closing.
That's a great point. That's a great point. Hey, Stephen, sales tax in Florida, and I don't know about other states around the country, but that can be an issue even with an asset sale. Do you want to touch on that and how that could affect?
The Department of Revenue, they have various levels of where you can invite them in to audit your business and limit that liability if you're a buyer. Sellers never want to engage in that, in my experience. It's almost exclusively done by escrow and set off these days. But they do have procedures that if it's a real high sales tax business, that you can go get, they'll audit the business, the Department of Revenue will audit it. They'll audit just to make sure returns have been filed, and they'll give you a separate certificate for that. But the only way you can be sure that there's no sales tax liability that transfers is to actually invite the Department of Revenue into the business and have them audit it. And I've not seen many sellers over the years willing to do that.
Oh, wow. I never heard of that.
It's always done with right of set off and an escrow at closing, because those liabilities do transfer. They don't transfer dollar for dollar. They're only liens against the assets of the business. In other words, I have had businesses where there's a sales tax amount owed, but the assets of the business have little value. And oftentimes when the Department of Revenue comes up and asks for their payment, most of those assets are already gone. They've already been replaced. That doesn't make the buyer responsible to make payment for those sales taxes. It just means that they're a lien against the assets of the business that were transferred to the buyer. So I've had buyers successfully show that to the Department of Revenue and not have them proceed against the business because there's nothing left to go after.
Right.
Well, that's good.
And if there's nothing, when you walk into a business too, what we start doing is having people do the tax transfer almost immediately, because you can tell if there's liens or problems or things that are not 100% kosher as soon as they start making that application. So we get all the buyers to do that right away. Because a lien you can find, but if it's not a lien yet, it becomes an issue, and that buyer is not going to be able to take that over.
So I've always just seen a letter from the Florida Department of the Sales Tax Office saying that all the sales tax has been paid and up to date, but I've never seen an actual inviting them in to doing an audit, which
All that letter does
which would scare me too.
All they're saying in the letter is that that there have been returns filed for every quarter, and what was shown on the returns was paid.
Right, exactly.
That's all it means. It doesn't mean there's no sales tax liability.
Right. I still don't know if I was a business owner, I'd be very happy inviting government officials into the business to start, going through the books if they don't need to. And I run a clean business. I just feel ever,
Right.
It's not something I'd want, but I don't know.
Well, it's an interesting situation when you think about who actually polices this. It's the Attorney General's office. If people are late and they don't pay their sales tax, the Attorney General has to be paid, and it can't be paid by a regular check. At that point, it has to be a cashier's check. So they're very, very careful, what they do. And actually, if it's an ABA, if it's an ABT problem, they come with guns. Actually, that's how they happen. They come into the place with guns. We want our money.
Let's talk about post-closing. How a lot of the times with post-closing, the seller is one of the big things with post-closing. The seller has to, train the buyer, and how do you protect from the situation where the seller that closes and they're like, wait, I'm done, and they just don't show up on that Monday to start training the buyer. How can that be prevented? Make that part of the promissory note.
Yeah.
Okay. And Stephen, you minimizing personal guarantees. I know that you're big on that, and you're trying to do that across the board, right?
Representing a buyer, I try to. You're not oftentimes successful in doing that. With a lease, it depends upon the sophistication of the landlord. Oftentimes when they have the seller as a guarantor, they're not as critical about getting the buyer as a guarantor. So if I can do that, I will. If I can have my buyer not sign as a guarantor on a lease, I'll do that. If they cannot assume contracts individually, I'll try to have that occur too. But knowing all the time that any sophisticated other party to a contract is going to generally want a guarantee.
Right. Yeah, it's very hard not to get a personal guarantee on a lease, for instance. Very hard.
Jim, if I can just add one more thing too, it really depends how you draw up your corporate papers as well. I've had husbands and wives want to be on the corporation, and I've just suggested, let's just put the husband on at this point in time, so the wife is not going to look to sign a personal guarantee, because a landlord will generally look directly at what you have over there in the corporate entity.
Okay. So what kind of searches, Ken, do you do for a buyer prior to closing? Legal searches.
Yeah, we want to see a general lien search, certainly. In Florida, we look at the Secretary of State website. We look at the Florida UCC filings. We look at local filings, lawsuits that could be against the company. Any of those items I think are very important. I think it's important to do a Google search, as basic as that sounds. Who is the seller? What's the company? What kind of recommendations do they have online? What do they look like on Yelp and Google? And what other kind of information can we find out?
Okay, great. Stephen, is there anything that we didn't cover today that you think? I know there's still a lot of stuff that you guys conversations you would want to have with a buyer. I want to make it very clear this video is not meant to, replace an attorney when you're looking to buy a business. You definitely got to hire an attorney to review all this. There's so much information you need to look at. But is there any key points, Stephen, that you think we missed that you want to make sure that we cover today?
I would say representing a buyer, and I could come up with 100 different things, but I'll try not to use all the rest of the time that you have. But I would say in the pre-closing stage, a buyer should make sure that they have a business under contract that doesn't go out of contract. And that generally is the broker's responsibility, but sometimes there's no broker involved. And even if there is, sometimes they're not like you where they're on top of everything. But if a contract goes out of contract, the buyer has no rights at that point to enforce the contract. And I've had a number of those happen where they go out of contract and the seller finds a better offer. And the buyer has no enforceable contract at that point. They didn't close in time. The contract's expired. So I always want to make sure from a buyer's perspective that they're under contract right up to the point of closing.
And it's kind of, I kind of look at it as like prior to closing, a seller has all the control, but once you go under contract, that control shifts to the buyer. I guess that's not really a legal situation. That's just my mentality as a business broker. And that's why I tell my sellers, once you sign that contract, that the power shifts to the buyer. So I don't know what you guys think about that, but
I've got one matter that I'm on the outskirts of the litigation. I think, Ken, your firm is still involved in that, where the contract had a date that the closing had to occur by. And all the parties, even after that date passed, were still negotiating closing document terms. And the date for the contract to close had passed. So when those negotiations fell apart, of course, the seller's defense is, well, you didn't close by that date. So you're out of contract. The contract expired. We don't have to close with you anymore. We're moving on to either not selling it or moving on to another buyer. So you can't, I don't think you should rely upon the fact that there's discussions after a closing date has expired to say that you still can enforce the contract as a buyer. You need to make sure that extensions are done as needed to closing dates.
Mm-hmm. All right, that's a really good point,
The buyer has no control.
I want to add into that. I think it's important that while Stephen's talking from the buyer's perspective, and he's absolutely right, that they need to be aware of that. In this particular case, there were tremendous amount of negotiations continued after the date, and there was, it's pretty clear, and certainly my position of my client, who was the seller in this matter, that the contract negotiations were ongoing, and so the date didn't terminate the contract at that time. But there's a lot more to the detail to it, but the point is well taken that Stephen has raised.
If I could just bring up something too, Jim, we didn't talk at all about work in progress.
Oh, WIP. Yeah. Talk a little bit about WIP.
Yeah. And I think WIP is really important because if we don't have something at the very end showing what is outstanding and what is due to buyer and what's due to seller, you're opening yourself up for a major problem after closing.
And WIP can be work in progress can be very tricky too. I mean, that's something that you really have to work out.
And it's really
sometimes it's hard to determine how far into a project somebody is.
I'm doing one client right now, and the industry is such that when they do the advertising to get the client, they're counting that as part of the WIP.
Oh, wow. Wow.
So you got to just look at the formula and see what they're doing there. And accounts receivable, I think, is something you have to look at as well. If the buyer is taking accounts receivable, and I think that we didn't really address that either.
Okay. Do you want to elaborate on that?
Well, I'm just saying if they're getting accounts receivable, we want to make sure, the date, if it's 90 days old, how long it's been out over there. And if they're not getting accounts receivable and they're really just helping the seller, we have to put provisions in there for that as well to make sure that they're not a collection agency and letting seller continuously harass the clients.
Right. Ken, is there anything that you want to add?
I was going to say work in progress. It was something we hadn't talked about, but Deborah got that one. But I'll just chime in a little bit more on that, we do a lot of deals involving property management companies, vacation property management companies, and they have a lot of issues around it's not really accounts receivable, but it's everything from deposits to how they attribute the money that they receive as a deposit. Some of the businesses claim that as soon as they receive the money, X amount of it is earned because it's used for advertising on the rentals. And then the buyer has no idea that that's the case. They see the deposit amount that's been received by the seller business and think they're going to be getting all of it. And then they have a big fight afterwards over who should get that additional money. And so that's always a big deal to try and make sure you understand how seller is accounting for their revenue and expenses and coming up with their accounts receivable and their WIP and how it works.
Mm-hmm. Mm-hmm. I think a lot of time, I want to add my 2 cents. And if you guys think of anything else you guys want to add when I get done, that'd be great too. One of the things I want to point out is that I think a lot of times business brokers and buyers look at due diligence as that this is financial due diligence. And, they hire a CPA, which they should, or they hire a financial person, which they should, to verify that the seller is really doing what they're claiming they're doing and to check out the financial situation. But, the other part of that due diligence is legal due diligence. And, they should be hiring an attorney to not just help construct the contract to protect them, but, also to do, any legal due diligence. I mean, bigger the business is, the more important that is. But, I did want to throw that out there that, that's important as well. So.
No, that it is. And I think we didn't really touch on insurance issues as well, but you have to be careful too when you're taking a certain type of business. If you're going to do a diving industry, if you're going to do something over there that you're going to pick up some of the liabilities as far as on your insurance payments, you want to be very careful what you have there. And you want to look at all the insurance and make sure the insurance is all in place at time of closing, because that becomes a major issue.
Great. I appreciate that, Deb.
Jim, do you find a reluctance in your industry to business brokers advising buyers and sellers to use legal counsel at the time of contracting?
I do. And, this is my take on it. What scares me as a business broker is when a buyer or a seller, not scares me, but I get concerned when a buyer or seller wants to talk to their attorney. And what I try to convince them is, go ahead and talk to your attorney, but you really need to hire somebody that specializes or works in this arena. Somebody that's used to doing, business sales or M&A work or something like that, because they know what's involved and what is right and what's wrong. You know what I'm saying? You take an attorney, a regular business attorney that's never been in the sale of a business, they can really make things really bad and really ugly very, very quickly. And I'm going to give a quick story that happened to me last year with a very, very good business broker working on the other end, where we had, I'm not going to say which one of the attorneys, but we had two attorneys, one for the buyer, one for the seller. One of the attorneys was good. The other attorney was probably a very good attorney, but the attorney was not familiar with what's normal in the process of selling a business. And we came to a screeching halt to get the deal done. And we had to hire a third attorney. Me and the broker did. We had to pitch our own money in to hire a third attorney to mediate between the two attorneys. And that attorney was Deborah Carmen that we hired to mediate that. And, it stemmed from the fact that there was an attorney involved that just didn't seem like they knew what was normal or not, at least in my opinion. I'm not trying to get anybody in trouble. Am I safe in saying that, Deborah, or should I edit that out?
You're okay with it.
But Jim, I think it's important for your business broker colleagues to understand that the best way they can insulate themselves from potential liability down the road is to have each party represented.
Yes.
I agree.
Yes. And here's 3 or 4 names of attorneys in the industry. I like to give multiple names. Here's 3 or 4 attorneys. Talk to them, and you might want to talk to your own business attorney, but, really you should be getting advice from somebody that does this all the time. Is that safe to say?
That's very safe to say, and it takes a lot of responsibility away from the brokers as well. And it becomes a team, and I always like a team effort. You have the broker, you've got the attorney, and you have the CPA.
Yeah. There's a saying, there's a saying that attorneys kill deals. Attorneys that don't know what they're doing kill deals. Attorneys that know what they're doing, it can cause some problems, and maybe a deal or two does go away, but maybe that's the deal that should go away. Because I'll tell you this, you don't also want to close on that deal, collect the commission, and be successful, and then on the completion of the deal, and 3 months later the thing's blowing up and there's lawsuits going back and forth. So I'm sorry.
One thing I tell. I was going to say one thing I tell prospective clients, Jim, is that they can pay me some now, or they can pay me a lot later. And I've seen that come true.
That's a great point. That's a great point. Did I answer your question okay, Stephen, from a legal standpoint?
Yes.
Okay. Yeah, it's just getting the right people involved. And somebody was chatting in the chat box saying that it's the same thing with CPAs, that it's important that whoever's doing the financial due diligence is familiar with doing financial due diligence as well.
I think that the attorneys that say, I'll see the business broker at closing and don't talk and don't have that rapport, those are the ones to stay away from.
Right.
But It's just going to come this check at closing.
And let's see, somebody had a question. I'm going to ask this question. What is your take on itemizing the value of each item on the asset list? Who wants to answer that? Stephen?
Talking about the asset allocation?
Yeah, and I don't think they're talking about the allocation, just the asset list, itemizing what the value should be. Like, you know, you give the asset list and putting a value next to each item. That's very looked down upon, right?
My comment on that, I don't know that there's a need for that other than from an accounting perspective, perhaps. From a legal perspective, no. I know there was some thought back in the day, and I don't even know if it's the current thought, that if you itemized equipment and didn't sell it as a list of equipment, if you itemized it and put prices next to each item of equipment, that the Department of Revenue would be more inclined to say that sales tax should be paid on that. Because you weren't selling it as a bulk sale of equipment, you were selling it itemized with dollar amounts. So I know I would always avoid having dollar amounts for the specific items of equipment, but itemizing between the other assets, you're gonna have to do it for tax purposes anyway. So I don't see a problem with it. And it's on your business listing information form.
You have to do that if it's over $5,000 for SBA. And that's where we see it.
Well, it's write down the price on next to the equipment list.
If something is over $5,000, then they want it itemized.
You know,
SBA
I do a lot of SBA loans. I don't remember ever having that, having an asset list and having prices next to them. I mean, I've always been told not to have prices next to, you know, itemized.
You're not going to have it at closing. I'm talking about prior to that when you're getting it done. Yeah.
Oh, yeah. Okay. Yeah, but the closing paperwork, I was always told,
no, we don't see anything.
Never put an itemized list in there, because then you got the challenges going back, if government's challenging things and things like that.
And I heard what Stephen said, and I do real estate as well, and we're very careful when someone is having furniture included. We never itemize the value of the furniture. We just give one price.
Jim, one other thing that popped into my head that I think that would be valuable for people to understand or to know on the buyer side, and this may have been covered, but I don't think so. When the buyer buys inventory, the buyer needs to make sure that they have their sales tax certificate. They've already registered with the Florida Department of Revenue. This is for Florida, probably similar in other states, but it's really important that you've got that reseller certificate exemption, essentially, that they give you in Florida, so that you don't have to pay sales tax on the inventory that you're buying because it's for resale.
That's a good point. That's a good point. Well, anything else you guys want to add? I know that there's, you know, a lot of other things that would need to be discussed, but, you know, we don't have 5 hours to discuss it. Is there anything else that you guys think brokers need to know this? I think that pretty much wraps it up. I mean, you know, this is my thought process, is that, you know, it's really important that attorneys, you know, are involved in the transaction. You know, they're not our enemies. You know, you just got to make sure that they are, you know, the qualified attorneys are involved in the process. And that's what you got to talk to your buyers and sellers about, is make sure that you get an attorney that's used to doing transactions all the time. They know what's right. They know what's wrong, what's normal, what's not normal. They're going to fight on your behalf to get you the best deal as possible. But at the same time, they're not going to go to the far extreme and do things that are just not normal, or dig in their heels and the deal's going to end up dying. You know, I think these three attorneys, I've worked with them all. They're all fantastic attorneys. And you know, I always recommend these attorneys we have with us today. But I am glad everybody joined us today. As always, work hard, work smart, keep making those buyer-seller connections, and we'll see you next week. Thank you.
Excellent.